Hi, and welcome, everyone. Thank you for joining us today. I am Stephanie Skaff. I'm a partner in our technology group here at Farella, and my practice focuses on primarily on platform companies, including social media companies. I am a trial lawyer, and I help advise clients both in pre-litigation disputes and counseling on avoiding litigation, as well as when litigation actually happens. I actually try cases, a lot of them. And I'm here today with Nate. Nate, you want to introduce yourself?
Yeah, thanks, Stephanie. I'm not a trial lawyer. I do not try cases. My name is Nate Garhart, and my practice focuses on intellectual property, privacy, and internet law, a lot of transactions and regulatory issues. So with that, it's great to have everybody here, and why don't we get started?
So we're going to try to cover quite a bit today, and the idea is for us to give everyone kind of a really high level look at what's kind of coming down the pike, both on the US side and the European and in the EU, with some legislation that's directed at platforms. Some of it specific to social media platforms, others more broadly directed at online and internet companies operating on the online. So there's let's go back real quick, Nate. Sorry. So on the US side, we're going to talk about two types of legislation. So we're kind of leaving privacy legislation to the side because that's a whole nother at least an hour. But we're going to talk a lot about kind of legislation that's focused on user harm, including harm from content, and legislation that's focused on marketplace harm. And that'll be kind of similar in both the US side and the European side, although as you'll see, and Nate will tell you, the EU is actually a lot farther ahead. Okay, so let's jump in to the legislative efforts in the United States. So there's two kinds of things that we'll talk about. The first is legislation that focuses on potential harm to users or impact on users. And there we'll see that that's really shifted in focus from regulations that directed at content and speech to algorithms and design. And then we'll look at the legislation directed at marketplace harms. So in the US, there's really, this is a fairly recent survey poll that was done, and there's really broad support for regulation of particularly of social media companies. And this is really fairly broadly supported by both Democrats and Republicans. And so there's some real bipartisan support for getting some regulation in place. The problem has been primarily in the past that there hasn't been consistency about what type of regulation people are looking to have. Let's take a look at. The first category is regulations that are designed to prevent some type of harm to a user. And in the past, we've seen a lot of, particularly at the state level in the US, legislation that was directed at prohibiting content. So legislation directed at content moderation decisions. So there was a deplatforming law that was passed in Florida that was intended to prevent social media companies from deplatforming candidates. And in Texas, was a similar but broader law that was directed at social media companies, preventing them from censoring user expression or user receipt of content based on a viewpoint. Both of those decisions were struck down under on preliminary injunctions and ruled likely unconstitutional under the First Amendment. So let's see the next slide real quick. We also have in the US something that has been kind of from the beginning of the internet, a piece of legislation that was really intended to protect and grow the internet social and content community. And that's Section 230. Section 230, for those who operate in this area, you know that it provides immunity protection. It's broad immunity for liability from harm that's caused by third-party content. And the idea is that internet service providers are publishers, that they are not the authors of the content, and that they're not responsible for the content that third parties users post on their services. Section 230 also was added a Good Samaritan immunity provision, and that provision gives ISPs immunity when they take action to restrict third-party content. So when they do take action in good faith, they're also given immunity under the Good Samaritan provision. So basically together, those two provisions do not require ISPs to take action to restrict content, but allow them to do so if they do it in good faith. So there's really kind of two holes in 230 immunity in terms of how it's limited. The first one is the good faith requirement. If an ISP does take action and moderates content, it has to meet a good faith requirement to fall within the Good Samaritan provisions. And that often requires a showing of consistency, that the action was not arbitrary or capricious. And then the second, and the place where we're seeing a lot of legislation fill in, is that Section 230 doesn't protect liability for a company's own conduct or content. And there's a recent decision that came out last year in the Ninth Circuit, the Lemon versus Snap decision, and that decision involved Snapchat, which is an app that allows people to trade pictures and videos of things that they're doing in real time. Snap had a filter called the speed filter that was used, that it made available. And three boys in Wisconsin were in a car and they were racing very quickly, and they were using the speed filter to measure their speed, which got up to 113 miles an hour. They crashed into a tree. All three of them died, and the parents sued Snap. Snap argued that it was protected under Section 230, and the Ninth Circuit reversed the district court dismissal of the case and found that Section 230 did not apply because what the parents were really suing for was product liability. That the design of Snapchat and the speed filter feature itself was promoting and encouraging dangerous behavior, and that was a defective design. So it was obviously at the early stage of the case, so it wasn't a decision that had actually happened, but it was a decision that the case could proceed on that grounds, and that Section 230 would not provide immunity. Let's go to the next slide. So with that background in place, there was also, and probably most of you heard about Frances Haugen, who was a whistleblower that appeared in front of Congress, and she testified. She's a former employee of Facebook, now Meta, and she testified about some of the things that, some of the design features of Facebook and also Instagram, which Facebook owns, and the risks and the potential harms that those system designs, and particularly the algorithms that are used to serve content, presented. And according to her testimony in the documents she presented, the types of algorithms and system design features that were used could spur hate, violence, and division because they increased the number of, because the posts that had hate, violence, and promoted division increased engagement, and so those would be served to users more often. And also that there were harms to the mental, emotional, and physical health of users, particularly minors. And she talked a lot about an internal study that that Facebook had done about the Instagram platform, and the internal information appeared to suggest that Instagram was increasing the risk of anorexia and other eating disorders amongst young women. So obviously, her testimony created some concern, and it also really helped shifted the focus of a lot of legislation away from what is the content itself to how is the content served to users and what are the underlying algorithms and designs that are being used. So this is my just little, let's make it simple on what an algorithm is. Basically, an algorithm is just a way, a computerized way of making decisions about what gets presented to a user. So if a user, for example, likes a particular post, or if they provide certain information about personal information, or if they engage with certain other users or groups, all those things might be factors that are fed into the algorithm and in turn produce certain types of content to increase the engagement of that user. And in many situations that can be fine, and it could be something that users want. But the concern is that it can also be used in a way that presents some harms to users, particularly if it's not transparent. So there's been an increase in a number of both US and state legislation that's targeted at algorithms. The first is what's called the Justice Against Malicious Algorithms Act. It's an act that is moving its way through Congress, and it's narrowly directed to amend Section 230. And this act would basically make it clear that Section 230 does not provide immunity for an online platform company that knowingly or recklessly uses an algorithm or any other technology to recommend content that contributes to physical or emotional injury. So this is a little bit broader than what we saw in the Lemon case from the Ninth Circuit, where the Ninth Circuit said that this case isn't about content at all. It's just about a design that ultimately encouraged behavior that was dangerous. This the U.S. law would actually increase to cover content as well, harm that came from content. So I'm going to go quickly through some of the others that are out here. We'll look at this one. I put on put some information about there's two bills proceeding, one in the Senate, one in the House, both called the Algorithmic Justice and Online Platform Transparency Act. And these would apply to any online platform that uses an algorithmic process to withhold, amplify, recommend, or promote content. So these are broader than this is targeting a broader cross-section than just social media companies. And it really is focused on two things. One is transparency and disclosure of the various algorithmic processes that are used. And the second is maintaining the records, but it also has a provision that is really directed at algorithms that are biased or that discriminate against protected categories, that affect voting rights, or that produce discriminatory outcomes. There is also another act that just got introduced in March called the Algorithmic Accountability Act. And that one requires the FTC to do impact assessments of automated decision systems. And that one's directed at larger companies greater than $50 million in revenue. But those are also, that act is also directed more toward the bias that can arise in algorithms. So it's directed at algorithms that are used to make critical decisions that might affect individuals, decisions about housing, financial services, and other basic day-to-day employment, things like that. California also has some pending legislation that's primarily targeting algorithm bias, particularly in the financial services industry. That's AB 13. Right now, that's been amended, so it's limited to states' acquisition of those types of systems, having to do an analysis of the bias in algorithms. There's also a set of social media legislations that are targeted also again at design / algorithms, but are really directed specifically at social media companies, and particularly the engagement with minors. California is the farthest along in that. It has the Social Media Platform Duty to Children Act, which is getting a lot of support. That act is very, it's pretty extensive. It requires, it makes an express duty of care on social media companies to affirmatively act to prevent and mitigate harm to minor users. And the liability provisions as they are in the act right now are very broad. It's really trying to prevent addiction to social media. And addiction is basically just defined as preoccupation with a platform that eventually causes some kind of physical, emotional, or developmental harm. It allows a private right of action, either as an individual or as a class action, with some significant recoveries of various kinds of damages, fees, and penalties. So this, if enacted, there are some safe harbor provisions, but they're not very clear, and this could really be a big driver of further litigation. It does not require physical harm, which is what right now most of the litigation that we've seen in the social media space has arisen from actual physical harm or death. The other set of U.S. Regulations that I want to talk about. So that's kind of a little quick glimpse into some of the legislation that's directed at harm to users. And there are a number of other legislative efforts going along both in Congress as well as in various states. But we're not as far along other than in the algorithms area and design area as the European Union is. In the marketplace harm area, let's take a look at some of what's going on there. So most of the activity in the directed at marketplace harm has really been in the litigation arena. I've highlighted the FTC action, the current action against Meta, Facebook, which just got a green light to go forward based on a minute complaint. And in that action, the FTC is alleging that Facebook improperly maintained monopoly market power by doing a couple things. First, acquiring competitors and potential competitors like Instagram and WhatsApp, and then also implementing policies that prevented interoperability with other competing apps. And there's other actions like this against other companies out there. I don't mean to be solely highlighting Facebook, but this one is pretty well known. And it's very large and has pulled in a lot of other companies as well. The US is also working on, Congress is also working on some legislation that is specifically targeted at marketplace harms as well. Two that are very broad are the Platform Competition and Opportunity Act. There's a version of that in the Senate and in the House. And then there's also the Ending Platform Monopolies Act, which is going through the House right now. Those are really directed at very large platforms, so greater than 50 million monthly users, or 100,000 monthly business users, and greater than $600 billion in market cap or sales. And what the Platform Competition and Opportunity Act would do, it would simply prevent acquisitions by a covered platform, unless the platform itself shows that they meet non-competitive exceptions. And it's set up so that the platform itself would actually bear the burden of demonstrating that it met one of the exceptions, and it would have to show that by clear and convincing evidence. So it's basically a stopper on large platforms acquiring other entities. The Platform Monopolies Act is similar, but it's actually not limited to acquisitions. It's preventing large platforms from owning multiple lines of business, so even owning or operating, so that it would apply to existing businesses owned by large platforms. There are also a number of legislative efforts directed a little bit more narrowly at specific marketplace harms. One that's getting a lot of attention is the Access Act. That's HR 3849 going through the House right now. That act would require, again, directed at large platforms, and that is really focused on portability and interoperability. So it's intended to facilitate users and businesses switching between platforms. The American Choice and Innovation Act, there's identical bills going through the House and the Senate. That act is focused on discriminatory conduct by online platforms. So that's preferencing their own products or business lines, excluding or disadvantaging competing products. And it also deals with some interoperability. That one is most like, I think, what Nate will be talking about in the EU later on. And then there's a more narrowly drafted act called the Open App Markets Act. And that one also has identical bills going through the Senate and the House right now. That is focused on preventing companies from privileging their own apps. And also it would ban the use of a company's own payment systems for app purchases. And then it tries to increase the number of third-party app stores. So that one's really more narrowly directed at Apple and Google, who have the two prominent app stores out there. So that's kind of an overview. I know I ran through that very quickly, but I want to make sure and give Nate time to talk about the legislation that's moving through the EU, which is a little bit farther along. All of those pending all the legislation that I just discussed is all pending. None of it's been enacted yet. So it just gives us a sense of the areas as that we are going to be seeing legislation and new regulation in some of the in these kinds of areas. And it's just a heads up of the types of things that we might see and how we can, prepare for those in the future. So Nate.
Great. Thank you, Stephanie. So a couple of preliminary things. First of all, what's our purpose of looking at the EU legislation? Many of you may have companies or clients where it's directly relevant that you're going to have to comply with these things, or your clients are going to have to comply with these things. But that's not really what we're here to educate you on as far as compliance and the like. And you'll have to talk to EU lawyers about that. But more, what I'm looking to do here is give you a sense of what's going on in the EU so that we can look back at those US actions and see where some of it's coming from, the ideas behind them, and where some of it may go based on what the EU has done so far. The second caveat is, again, that we are not EU lawyers. We're not licensed to practice EU law. And therefore, of course, this isn't legal advice, but you definitely should take everything with a grain of salt here and consult EU counsel if you do have specific questions about the EU legislation, its effects, etc. So jumping into this, the stated objectives from the European Commission in drafting these laws are really reminiscent of what Stephanie was just talking about. You see the first objective, to create a safer digital space for users. Again, just as Stephanie said, that is looking at harm to users. And so very clearly a parallel in the objective here. The second objective, Stephanie mentioned guarding against harm to the marketplace. Well, to establish a level playing field to foster innovation, growth, and competitiveness, both in the European market and globally. That is all about preventing harm to the market. So very similar objectives. And again, these are the express objectives that the European Commission stated in passing the laws. So to fulfill these objectives, the EU has introduced two new laws, the Digital Services Act and the Digital Markets Act. And to give you an idea, Stephanie had mentioned a few times that the EU is farther along on this. Well, here's where they are. This was introduced in December 2020, and they've gone through a number of steps. We're nearly at the final step. They just need to get some parliamentary approval. And it's really, both of these laws are likely to take effect around October 2022. So they're in their final forms and they're pretty much ready to go. So let's talk about each one a little bit. First of all, the Digital Services Act. Who does it apply to? Well, it applies to intermediary services offering network infrastructure according to the Act itself. Well, who is that? It's access providers, domain name registrars, hosting services. Wow, it seems to apply to a large swath of online companies. That said, it doesn't apply to small businesses that don't really offer access to products and services of third parties and their services. So, you know, if you have an online page and sales page for your winery, for example, not likely to be an issue under the Digital Services Act. But you do have to look at it on a case-by-case basis. The other thing that's really interesting is when Stephanie was talking about the US laws that protected users, they tended to specifically look at content and whether that content should be of concern, whether there should be action permitted to be taken against such content or harm from such content. The Digital Services Act looks at it a little differently. The provisions address what they call illegal and sometimes harmful content, but they don't define what is illegal. Instead, they say, look to the national laws or general sense of what might be harmful. But instead of defining what's illegal, they say, look, you're going to have to do due diligence and provide reporting as to illegal and harmful content that could be on your site or that you're serving up to users. The level of obligations of those diligence requirements and reporting requirements varies based on who you are. So the most onerous is for very large platforms. That's defined generally as about 10% of the EU population, those that have 10% of the EU population using their services. Then there are some obligations on other online platforms, fewer obligations on hosting services, and then if you don't fall into any of those categories, you have the least onerous requirements. And here is directly from the EC. This is generally what those requirements are. And I'm not going to go through every one of these, but you'll have this slide and you can take a look. But as you can see, the very large platforms have a lot more that they have to deal with than, say, a smaller intermediary service. So what are some of the bigger requirements? Well, first of all, in the EU Commission's words, the Digital Services Act significantly improves the mechanisms for the removal of illegal content and for the effective protection of users' fundamental rights online, including the freedom of speech. It also creates a stronger public oversight of online platforms, in particular for platforms that reach more than 10% of the EU's population. So what concrete steps does it take? Well, first, it has measures that counter illegal goods, services, or content online, and includes a mechanism for users to flag such content and for platforms to cooperate with trusted flaggers, those that have been given kind of a mantle of propriety and a mantle of authority to flag illegal goods, services, or other content online. There are also new obligations on traceability of business users in online marketplaces, and that will help identify sellers of illegal goods or reasonable efforts by online marketplaces to randomly check whether products or services have been identified as being illegal in any official database. It includes effective safeguard for users, including the possibility to challenge platforms' content moderation decisions. The Act has a ban on certain types of targeted advertisements on online platform, and those are where they target children or where they use special categories of personal data such as ethnicity, political views, or sexual orientation to target the advertising. There are transparency measures for online platforms on a variety of issues, including on the algorithms used for recommendations, so they'll have to disclose those algorithms. There are obligations for very large platforms and very large online search engines to prevent the misuse of their systems by taking risk-based action and by independent audits of their risk management systems. They're also going to have to provide access to researchers so that those researchers can see the key data of the largest platforms and search engines in order to understand how online risks evolve. And a final highlight is they are putting in place an oversight structure to address the complexity of the online space. EU countries will have the primary role, supported by a new European Board for Digital Services. For very large platforms, supervision and enforcement will come from the European Commission itself. So there's a lot in there, and there's no question that it's going to be very disruptive and require a lot of transparency that is certainly not the norm at this time. Reasonable minds can differ on whether this is going to be helpful, whether it will truly protect users, and how it will affect companies. But in Europe, this is the law of the land, or will be in October. There's a lot of gray, though. The European authorities themselves have admitted that it's not really clear how this is all going to play out. So we really need to take our time and see how this moves forward. But you can see a lot of what is stated here is echoed in some of the legislation in the US, which, as Stephanie noted, is really in its beginning forms. So the US legislators will have the benefit of seeing how some of this plays out and whether it's worthwhile to pursue similar strategies in US legislation. So moving off of the Digital Services Act, which again focused on harm to users, let's look at the Digital Markets Act. The idea is that large companies with control of the market, that is what they call gatekeepers, can create bottlenecks between businesses and consumers or otherwise control entire online ecosystems to the harm of the market. The Digital Markets Act attempts to address the negative consequences arising from certain unfair behaviors enabled by the size and the entrenched and durable nature of these gatekeepers. And so that immediately begs the question, well, who is a gatekeeper? And there is a qualitative definition that basically says a gatekeeper is any company that has a strong economic position and has a significant impact on the European market and operates in at least 3 EU member states, and also works as a strong intermediary such that it links a large user base to a large number of businesses. So at the end of the day, it's somebody that can really control and affect the market. But realizing that that was going to be very hard to implement, they did include a quantitative definition. And this is a rebuttable measurement. If you qualify under this, you can argue that you should nonetheless not be deemed a gatekeeper. But the quantitative look says a gatekeeper is any platform that has annual revenue of at least 7.5 billion euros or a valuation of at least 75 billion euros and has at least 45 million monthly EU end users and at least 10,000 annual EU business users. And additionally, that the platform controls one or more core platform services in at least 3 EU nations. And there's a lot of talk about all of this. Most of the talk has been about, or a lot of the talk has been about 2 things. First of all, that this pretty much targets American companies for the most part. This is going to target Apple, Google, Microsoft potentially and the like. It's not going to target many of the EU companies that offer similar or competing services because they simply don't meet these gatekeeper quantitative requirements. The second thing is there's a lot of discussion about what is a core platform service. And the platform services are listed, but that's likely subject to change. And so there's a lot of talk again about how can we work with this when what's a core platform service today may not be tomorrow. And so let's look a little bit deeper into the Digital Markets Act. So what are the benefits? And this is according to the European Commission. Again, there's a lot of debate about this, but according to the European Commission, business users who depend on gatekeepers to offer their services in a single market will have a fairer business environment. Innovators and technology startups will have new opportunities to compete and innovate in the online platform environment without having to comply with unfair terms and conditions limiting their development. Consumers will benefit as they will have more and better services to choose from, more opportunities to switch their provider if they wish to do so, and direct access to services at fairer prices. And finally, the EC states that gatekeepers will keep all opportunities to innovate and offer new services. They will simply not be allowed to use unfair practices toward the business users and customers that depend on them to gain an undue advantage. So what are some of these obligations that are going to create these benefits to everybody? Well, specifically, among other things, gatekeepers will have to, first of all, ensure that users can unsubscribe. They're going to have to give users a choice of software to use. So when you're in their ecosystem, you won't be required to use their payment system, and instead will have to be able to opt to use various payment systems. They'll have to allow interoperability of certain core functions. And an example of this is in the messaging platforms, they'll have to make sure that you can message from any other platform or service, and that you won't be locked into only being able to engage in that function if you are within the given platform's ecosystem. So again, in the messaging apps or messaging platforms, the idea is they'll have to enable one-to-one conversations, but not necessarily enabling other functions such as group chat. So again, one of the things that I keep repeating or reading again and again as I look into these is we're not really sure how this is going to play out and where are the limitations around these? Where are the boundaries? What is a core function? A lot of this is really up for debate. But at any rate, you're also going to have to give businesses access to the data that they generate on the platform, certainly very different than what we have now. And you'll have to enable businesses to promote and sell outside of the platform. So that's pretty much the idea of sideloading in an app store. You should be able to put that app on your phone from the direct site of the seller rather than having to go through the platform store, the App Store, or the Google's App Store. And finally, it will require the gatekeepers to inform the European Commission of their mergers and acquisitions. So those are the obligations. It does list out some prohibited activities. And what are those? Basically, the gatekeepers are going to have to treat services and products offered by themselves equally favorably, but not more favorably in ranking than similar services or products offered by third parties on their platform. They are going to be prohibited from preventing consumers from linking up to businesses outside of the platform. They won't be permitted to prevent users from uninstalling any pre-installed software or app if they wish to. And they will have to track end users outside, they won't be permitted to track end users outside of the core platform service for the purposes of targeted advertising without first getting effective consent. So they definitely put some teeth into this, into the Digital Markets Act, and provide for penalties that are very significant. An initial violation can carry fines of up to 10% of the total worldwide annual revenue of a gatekeeper. And that increases to up to 20% with repeat offenders. If there are 3 or more violations in 8 years, those gatekeepers could be subject to structural remedies that would redo how they do business and directly affect the structure of the company. So they're really taking a strong position on this, no question. So really at the end of the day, again, the gatekeeper companies, it's pretty clear who is likely to be a gatekeeper company or deemed to be a gatekeeper company. Very few companies will actually qualify for that. And so the question then is more on the DSA side. Who is that going to apply to? And arguably, it could be applicable to many US companies that fall within the definitions put forward for those that have to make the disclosures and the reporting and the diligence under the DSA. But the bottom line is the risk is likely very low unless a given US company has EU operations. But there are other considerations that the companies will have to think about. First of all, are they in contracts with EU companies, vendors or partners or others that you're working with, where the contract calls for compliance with the duties imposed under these laws? It's going to be important to look at those contracts. We saw that a lot with the GDPR as far as privacy. When working with EU vendors, you got a lot of contractual provisions that required compliance with the GDPR, even though the company itself here in the US was likely not subject to the GDPR. So I expect to see that again. The other thing to keep in mind is that if you're a company that falls under the threshold or isn't worried about reporting necessarily, but you're interested in being acquired by somebody that very likely would have to report or otherwise be subject to the DSA, you might consider how you go about structuring things and the reporting and diligence that you undertake to make yourself more attractive to some companies, to an acquiring company. But again, hard to see how that's going to play out. It's going to take some time. And I expect over the next few years, we'll see how this really shapes actions and behaviors around US companies. So thank you. That's what we wanted to cover today.